any multifamily building with more than 4 units would be considered commercial. And if you're talking about real estate that's undeveloped, then you look to the zoning. And this is where you sort of potentially get into discrepancies across different jurisdictions, and the federal government has gotten into this a little bit recently with respect to some money laundering reporting requirements. But generally speaking, if there's no structure on the property, then you look to the zoning, and if it's zoned to be commercial, then it's commercial.
Welcome to CRE Radio for influential commercial real estate professionals who work with investors, buyers, and sellers of commercial real estate coast to coast. Whether you're an investor, broker, lender, property manager, attorney, or accountant, we're here to learn from the experts.
Welcome to Commercial Real Estate Pro Network's CRE Radio. Thanks for joining us. My name is J. Darren Gross. This is a podcast focused on commercial real estate investment and risk management strategies. Weekly, we have conversations with commercial real estate investors and professionals who provide their experience and insight to help you grow your real estate portfolio. Today's interview is sponsored by Building Insurance and Risk. When you invest in real estate, it pays to work with a real estate investor protection specialist to protect yourself and your investment from catastrophic loss. The experts at Building Insurance and Risk focus on real estate investor protection. They provide you with multiple insurance coverage offers and a side-by-side coverage comparison. To learn more, go to buildinginsurancerisk.com. Today, my guest is Andy Mathews. Andy is a real estate lawyer at Stoel Rives in Seattle, Washington. And in just a minute, we're going to speak with Andy Mathews about real estate law. But first, a quick reminder. If you like our show, CRE Radio, there are a couple things you can do to help us out. You can like, share, and subscribe. And as always, we encourage you to leave a comment. We'd love to hear from our listeners. Also, if you want to see how handsome our guests are, be sure to check out our YouTube channel. You can find us on YouTube at Commercial Real Estate Pro Network. And while you're there, please subscribe. With that, I want to welcome my guest, Andy Mathews. Welcome to CRE Radio.
Darren, thank you very much. It's great to be here. Thank you for having me.
You bet. I'm looking forward to our conversation. But before we get started, if you could take just a minute and share with the listeners a little bit about your background.
Yeah, great. Thanks, Darren. I am a lawyer at the law firm Stoel Rives, which is a significant regional law firm, and primarily in the Western U.S., but we've got offices all over the country. I'm a real estate lawyer. I represent a wide variety of clients and actors within the real estate space in both disputes. So I do litigation as well as transactional and advising work. I represent a significant amount of my client base are real estate firms, so real estate brokers who represent buyers and sellers, both in commercial and residential transactions, and therefore, of course, including real estate investors. I represent multiple listing services, again, both in the commercial and residential space, and I represent, like I said, parties in transactions and in disputes over transactions that maybe haven't always gone the way that folks wanted them to.
Got it. Well, let me ask you, just to start with, you mentioned commercial and residential, and before we started recording, you mentioned how some of the new laws and how they treat things differently, and I'm just kind of curious. Can you describe kind of the context or the lens on how that is viewed, meaning the residential versus the commercial?
Yeah, absolutely. It's a great question, and the answer that immediately jumps to mind, which has been a hot topic over the last few years, is revisions that lots of states, including Oregon and including Washington, where I'm located, have made to their agency laws with respect to requiring real estate licensees to enter into written services agreements with their clients. And it has always been the case that when you are a real estate agent and you represent a seller, it is since basically the beginning of time, you represent a seller or a landlord who wants to sell or lease their property, and you enter into a written listing agreement. It has not always been the case that if you are representing a buyer or a tenant, that you would enter into a written agreement. And there's a lot of reasons, and we could go down a long historical rabbit hole about that. But the answer to your question is, in the last couple of years, states have started revising their laws to require real estate licensees to enter into written agreements with all clients, regardless of whether they are the seller or the buyer. And there's lots of reasons for that. The primary reason is to ensure that there's transparency to all involved in a real estate agency relationship about how a real estate licensee is compensated. However, what a lot of states, including Washington and Oregon, have said that although we are going to require all licensees to enter into a written services agreement with their client, we're going to create an exception for licensees who represent buyers of commercial real estate. And there's lots of reasons for that, and perhaps the reasons vary from state to state. But it certainly reflects the fact that a party who's buying a 50-story office building like the one I'm sitting in downtown Seattle is different in terms of sophistication and a lot of other things from someone who's buying a single family house in suburban Seattle. And so the laws draw distinctions between licensees who represent commercial versus residential buyers, and that's one way in which there is a distinction between commercial and residential.
So for the line though between commercial and residential, I know like like a single family is clearly a residential property. I think most lenders and even I know like insurance treat like 1 to 4 units as like more residential property. It's when you cross the number of 5 that things start to be viewed differently. Does that same kind of a view hold true with respects to the legal interpretation for the
Yeah,
exception?
yeah, exactly. I mean, certainly in Washington, again, where I am, the distinction is clear, or the legal definition of residential versus commercial is clear. If you are 4 residential units or less, that is residential, and if you're more than that, so any multifamily building with more than 4 units would be considered commercial. And if you're talking about real estate that's undeveloped, then you look to the zoning. And this is where you sort of potentially get into discrepancies across different jurisdictions. And the federal government has gotten into this a little bit recently with respect to some money laundering reporting requirements. But generally speaking, if there's no structure on the property, then you look to the zoning. And if it's zoned to be commercial, then it's commercial. And if it's zoned to be residential, then it's residential.
And with that zoning, if it were bare ground that was going to be subdivided in that, is that still considered residential then, or would that be because you're doing, say you're doing more than 5 units, you've got an 80-acre parcel that you're going to develop and put in a subdivision, or is that, I would assume that'd be commercial, but if it's all the uses residential, would that?
Yeah, I mean, before it gets subdivided, if it's zoned in a way that would facilitate a commercial use, then it would be commercial.
All right. And you mentioned the I guess the driving force or the focus behind this recent change was to prevent or to I guess more easily identify any kind of money laundering situations. Can you describe? I mean, just kind of an example of what they were trying to nab or kind of catch.
Well, yeah, I mean, maybe I want to be clear. There's two different developments I was talking about. One was the revision of agency laws in the different states. That has, as far as I know, nothing to do with money laundering. The money laundering issue that I was talking about has more to do with a recent rule that was enacted by the U.S. Department of Treasury's Financial Crime and Enforcement Network, which is um, colloquially abbreviated as FinCEN, in which they are now requiring for any transaction involving residential real estate in which at least one of the buyers is an entity, you have to provide a fairly detailed report regarding the nature of the property, the nature of the parties, and with respect to the buyer, all of the beneficial owners of the entity. There are some certain exceptions involved. So, oh, and this applies to non-financed transactions. So if the buyer is obtaining a loan which is secured by the real estate, then it's outside of the scope of this reporting requirement that I'm talking about. But if you are engaging in an all-cash transaction using an entity, then there are certain reporting requirements with again some exceptions. So it doesn't apply to publicly traded companies. But certainly if you are a real estate investor and you are using an entity to purchase residential real estate and you are not financing it, something you definitely want to be aware of, because when you get to closing, the closing agent is going to be required before they effectuate the transaction to generate this report that gets sent on to the Department of Treasury.
Got it. I was trying to figure out how that I remember, or just what they were looking for specifically with that, but I could see a cash buyer on residential real estate as opposed to if you're financing it, that'd be could be problematic. And then with respects to the balance of that, is it basically again like what you were saying? Is that just to clarify the relationship between the real estate professional and the parties they're representing, just so everybody's clear on who and how everybody gets paid? Is that kind of
Yeah,
the intent?
exactly. Yeah. So going back to the developments in state law in terms of requirements of written services agreements. Yes, the brokerage industry has sort of a checkered past in terms of transparency over how real estate agents have been compensated, and there has been in the last several years some pretty high profile class action antitrust litigation, and primarily, if not exclusively, involving residential real estate brokerage. But the gist of it is that the practices of the brokerage industry came under attack with respect to the way that real estate brokers were compensated, the lack of transparency, according to the plaintiffs, about to consumers about how brokers were compensated, and a large chunk of those lawsuits were settled a couple years ago, which resulted, in addition to some pretty significant financial payments, resulted in some changes in practices that were implemented across the country, stemming from rule changes agreed to by the National Association of Realtors, which was one of the primary defendants. But those changes and those issues sort of are very closely related to the concerns that were animating that have animated the state legislatures that have enacted these changes these changes in agency law that are designed to enable consumers of real estate brokerage services to understand exactly how their agent is compensated.
So, and I apologize, I haven't followed this situation that closely. I've been aware of it tangentially that it's, that it was playing out in the courts, and I knew there was a big announcement about it a while back. But what was the nature of the class action? Were there actual like scams, or was it just more a matter of some buyers that got upset, or I mean, were they? I'm just kind of were they sellers? Were the sellers? I'm curious who
Well,
was
it was
who was
both.
the injured party that was bringing the class action suit?
Well, and it depends on how cynical you want to get about it. There were plaintiffs' class action firms that came out quite well after these settlements. But setting that aside, the answer to your question is both buyers and sellers were plaintiffs in these lawsuits. The first plaintiffs, the first lawsuits that were filed were on behalf of sellers, and the argument was that so for a very long time, the way that compensation worked in a brokered transaction is that the seller would hire a broker to market and sell their property. And we're again primarily talking about, or in the lawsuits, we're primarily talking about residential, but the way it worked in practice applied both to residential and commercial real estate. A seller would hire a broker to sell their home. The seller would agree to pay their broker, some amount of compensation, call it 6%, and the broker would then would put a listing into a multiple listing service, and lots of multiple listing services had rules that required, in order for a broker to submit a listing in the multiple listing service, required the listing to contain a blanket unilateral offer of compensation to any broker who represented a buyer who bought the property. And the argument was that sellers had little to no visibility or ability to control that offer of compensation that was being made to the other side of the transaction, and that the requirement to make that offer to the buyer's broker artificially inflated the seller's cost in selling their house, and artificially inflated the amount of compensation that the seller had to pay to their broker, because some amount of compensation that the seller was paying to their broker was actually going to the broker on the other side of the deal. And so that was the gist of the lawsuit. The plaintiffs argued that arrangement was an antitrust violation under the federal antitrust laws. There were a number of lawsuits filed across the country. They were all sort of going on at the same time until in the end of 2023, the first one of them that went to trial resulted in a complete plaintiff's victory. The jury, and this lawsuit, which was pending in Kansas City, Missouri, and pertained only to transactions in the state of Missouri, whereas a lot of the other lawsuits involved transactions in many states across the country. The one that went to trial first was only in Missouri, and despite being only in one state and not a terribly big state, resulted in a jury verdict in favor of the plaintiffs for $1.78 billion. And that itself is a massive understatement of the value of the judgment, because those were the damages that the jury decided were suffered by the plaintiffs, which again, in that case, were sellers in the state of Missouri whose transactions were subject to a rule like what I described a minute ago. And under the federal antitrust statute, which is the legal basis for the claim that was brought in that Missouri case, if you are a prevailing plaintiff, you are entitled to a couple of things. One, you're entitled to treble damages, which is a fancy lawyer term for triple. And you're also entitled to recover your attorney's fees. So the true value of that judgment was well over $5 billion. Well, before that, before the appeals were done in that case, the parties in that case and in the other seller cases across the country reached a settlement, and that was what I alluded to a few minutes ago when I was talking about a settlement that resulted in a number of practice changes and of course a significant monetary payment by the defendants. But that in a nutshell is the litigation that was going on involving these claims.
Wow. That's so a model of business that had been in place for forever with real estate was got challenged and is now. So what's the resolution now? Is it? I guess it comes back to this compensation up front. So let me ask you the net sum of this. Does this mean that now if you're a buyer, you are paying your agent directly, or is
Well,
it?
oh, sorry, go ahead.
Well, no, or is it still the same thing, but now the seller knows that they're on the hook for both
Well,
the
that's a great question. And there is nothing wrong or illegal about an arrangement where the seller pays the buyer's broker's transaction. What is different now is that where things work properly, that arrangement is now completely out in the open, and the parties in the transaction have the ability to negotiate with each other. So it is now the norm um, well, it actually varies depending on where you are and depending on whether you're in a multiple listing service that is bound by the rule changes in the settlement, because not all are, but it is common now for a seller to still make an offer of compensation to a buyer that would compensate the buyer's broker. But the fact that that is now an offer that's made openly between the buyer and the seller enables the buyer and the seller to negotiate that. And that actually fits very well with the new requirement now for buyers to have written services agreement with their broker, because now a component of in any state that requires a broker to have a written agreement with their buyer client, or their seller client for that matter, one of the things that's got to be in that agreement is how much the broker's getting paid. And it's easy to imagine a lot of buyers, especially if you're a first-time home buyer, saying, "How am I going to come up with however much money to pay my broker in addition to the amount that I'm paying for a down payment on this house or whatever the piece of real estate is?" And for that reason, like I said, you can still request, and the seller can still agree to pay the buyer broker's compensation. It's just it's now a discussion between the parties and not an agreement between the brokers that happens outside of the vision or knowing of the buyer and seller.
So on some, is the way of doing business, is it essentially the same, but now you've got these agreements in place? And you've got an extra signature for an agreement, or has it structurally changed the flow of business?
I mean, it depends. It has encouraged a lot of brokerage firms to develop creative sort of pricing and representation models that maybe didn't exist before. I mean, you see a lot more like a la carte pricing, whereas the norm, the tradition in real estate brokerage is that you hire a broker, and the broker will, just do everything, and they'll charge you a flat percentage fee of based on the purchase price. Well, now you're seeing a lot more of offerings from brokers where, maybe I'll do I'll do the marketing, but I won't the papering of the transaction will be something not included or something additional, and there will be modifications of the fee arrangement based on what exactly the broker is doing if they're not doing everything.
Got it. So let me ask you. So we talked a little bit about the the law change and the kind of the structure of the agreement. Um, Beyond that, with real estate investors and just real estate transactions, can you identify some of the more common disputes that you've entertained or been been involved with?
Yeah, I mean, well, like I said, a lot of my clients are real estate firms, and so I inevitably have a lot of clients who believe that um, they've been stiffed by their clients, but by their clients for compensation. So I've got a couple different clients right now who I'm helping pursue commission claims against their clients. I also, frankly, for that matter, sometimes not as often, but sometimes represent parties on the other side of that coin. So participants, real estate buyers and sellers who run into issues or disputes with their real estate agent over money. I also am involved in some disputes that don't involve brokers, boundary line or easement type disputes. I've represented association, like homeowners associations or other types of large landowners that run into like um, so, disputes over usage rights and easements. And I also represent firms in regulatory matters involving, licensing departments who engage in auditing, and every state's licensing law has pretty specific and nuanced licensing requirements that govern real estate firms and what they have to do. And so they often run into issues with that.
Is there a threshold where, I mean, as an attorney, you get paid to do the work, but I'm just kind of curious if there's a threshold where people kind of dismiss it and just move on versus, uh, oh man, call Andy, let's get this thing resolved, kind of thing. I mean, is there a practical number to where it's advisable? I mean, you're not working for free, and just the cost of whatever it is. I mean, I'm just kind of curious how big are these numbers that I'm assuming if you're engaged, the numbers are significant. This is
Yeah,
not,
yeah,
this
and
is not.
it really varies. It obviously varies depending on the client. What their either risk tolerance or their appetite for being aggressive is. And it also depends, frankly, on the lawyer. I mean, if you had a different lawyer here who is at a firm of a smaller size than mine. I mean, my firm is relatively large, and we represent primarily institutional type clients, and my billing rate reflects that. And so if I often, not often, but I occasionally get a client who, wants to pursue a claim, has a really good claim, but maybe it's not of a dollar amount that makes sense for me to help them with, and I refer them to lawyers I know who can do it more economically. But that being said, there's always um, options we can explore for making it work with the client's objectives and their financial resources.
Right. And given that you work primarily with real estate firms, um, are they more often a residential transaction focus on disputes, or would it be more like on a commercial or a? I'm just going to trying
I
to
mean, I
understand.
like I said, I represent, both commercial and residential firms. I've got a commercial brokerage firm right now whose broker represented a landlord, and who owned a strip mall, and is trying to stiff my client on their commission for having located a tenant for one of the units within the strip mall. And um, that's a really great example of a type of matter that I handle.
No, I say that that sounds familiar.
Yeah.
Um, so I got to ask you, given the buzz about AI and all that, are you currently utilizing AI? Do you have any kind of a sense on how AI is or will be integrated in what you're doing with the type of work you do?
Yeah, I do. I do use it. My firm is very up on AI, and has given the lawyers here lots of good resources to use. I mean, just one example, I was working for a large client who's a institutional real estate investor management firm that operates all over the country, and they had a question involving that spanned many states, and I used an AI legal research tool that is available to me to do the first step of the research in a manner that was much faster and much more cost effective for the client than it would have been in the old days of either me or even a junior associate going through and doing all of the searches, state by state. It's really enabled me to do things like that and on a lot more efficient basis for my clients.
So I'm curious on that. There's your rate. Do you charge then a rate for the AI, or I'm just curious, how does that, or is it just integrated in the work you're doing?
Yeah, I mean, the example that I was just talking about was an AI tool that's built into Westlaw, which is one of the more popular legal research databases. And we don't charge clients for Westlaw use, which is, if we were having this conversation like 15 or 20 years ago, every firm would charge their clients for the amount of time that the lawyers spent on Westlaw, and that was a sort of bone of contention. But that's a practice that has changed and evolved over time, and the answer is no. The client
Yeah,
did not have to pay anything in relation to my use of that feature.
yeah. No, I'm just fascinated by how that's being incorporated in everything and the power of it. You know,
And it's a big deal for my clients. It's a big deal for real estate brokers and for real estate buyers and sellers. I mean, especially brokers. There are so many just fascinating AI applications out there that help brokers do things like generate opinions of value when they're trying to figure out how to advise their client on what price to set for their property, how to locate real estate. It's just, I mean, the opportunities are endless, especially when you're dealing with the vast quantities of data that exist, as I'm sure all of your listeners know, that exist in the world of real estate. I mean, there's just endless data out there, and if you have the ability to engage AI in analyzing that data for your benefit, it's really valuable.
Yeah, no, definitely a powerful tool, and I guess what I'm kind of starting to understand is it's more about learning how you can leverage that and how to ask the questions to get, more valuable output, is really kind of, the goal of at least what I'm understanding, that it's learning how to use it is really kind of the key, and doing that. So it's great. Hey, Andy, if we could, I'd like to shift gears here for a second. As I mentioned to you earlier, by day, I'm an insurance broker. And as such, I work with my clients to assess risk and determine what to do with the risk. And there's three strategies we typically consider. First, look to see if there's a way we can avoid the risk. When that's not an option, we look to see if there's a way we can minimize the risk. And if we're not able to avoid nor minimize, we look to see if there's a way we can transfer the risk. And as such, I like to ask my guests if they can look at their own situation. Could be your clients, the law, whatever forces you see that you consider to be the biggest risk. And again, for clarification, while I'm an insurance broker, I'm not necessarily looking for an insurance-related answer. And so, if you're willing, I'd like to ask you, Andy Mathews, what is the biggest risk?
Well, that's a great question, and I know you framed it as switching gears from our last topic, but I think there's a way in which it is related to the use of things like AI. And my answer is the biggest risk that I can think of is failure to stay on top of the things that impact you and your industry or your realm, and that applies equally to me and my clients. I mean, my clients, like I said, if we're still using the AI example, ignore AI and its offerings to their great detriment. And for me, I mean, AI is one example, but just I think the risk that I face as a lawyer, it's really easy to spend my days, as you alluded to. I like every other lawyer out there, I charge my day is based around the billable hour. And so anything that I do that's not a work that is billable to my client is something that is outside of what are the core expectations of me as a lawyer in my firm. And yet if I were to focus solely on the billable hour, I would be doing both myself and my clients a great disservice. And for that reason, I try to spend anyway, a good chunk of every day on things that I don't have the ability to bill any client for. But the purpose is to make sure that I'm staying ahead of the game, that I am aware of what's going on in the industry that in which my clients operate, so that when a client does come to me with a problem, that I'm able to bring a level of expertise to it that is helpful to them, and that is not just legal advice, but advice based on a business judgment and business understanding of how they are operating.
No, that sounds good. Definitely, you got to stay on top of your core skills there, and make sure that you have value. Can't be outsourced by AI, but definitely good. Hey, Andy, where can the listeners go if they'd like to learn more or connect with you?
Yeah, so I'm on LinkedIn. If you search for Andrew Mathews at Stoel Rives, you'll find me on LinkedIn, and I'd be happy to connect with anyone out there who's listening or watching, you can find me on my firm's website at stoel.com, and I'm listed there as one of the lawyers in the firm, and would be happy to reach out. And that if you find me there, that's got all my email address, phone number, all my contact information. So very, very happy to reach out and talk about these or any of the other topics that we've talked about.
Awesome. Well, Andy Mathews, I can't say thanks enough for taking the time to talk. I've enjoyed it, learned a lot, and look forward to doing it again soon.
Thank you, Darren. It was a pleasure being here. Thank you for having me.
You got it. For our listeners, if you like this episode, don't forget to like, share, and subscribe. Remember, the more you know, the more you grow. That's all we've got this week. Until next time, thanks for listening to Commercial Real Estate Pro Network's CREPN Radio.
You're listening to CREPN Radio for influential commercial real estate professionals. For more information on this or any of our guests, like us on Facebook, CREPN Radio.